This is an international law case. Whaling in the Antarctic. Australia versus Japan. New Zealand intervening. Judgment March 31st, 2014. Presented by Rebecca L. Delaria. ATE 3515 Legal and Ethical Issues in Veterinary Technology. Facts of the case. This was a case concerning whaling in the Antarctica and the alleged violations of the International Convention for the Regulations of Whaling, also going to be known as ICRW further in this case. Presiding judgment was President Tomka, Vice President Sepulveda Amar, Judges Owada, Abraham, Keith, Benuna, Kotnikov, Kankado, Trindade, Yusuf, Greenwood, Yu, Donahue, Gaja, Sebutinde, Bandari, Judge Ad Hoc Charlesworth, Register Covier. Attorneys for Australia: Mr. Bill Campbell, QC, General Counsel International Law. Attorney General's Department, Japan HE Mr. Koji Tsuruko, Ambassador Chief Negotiator for the Trans-Pacific Partnership Agreement negotiations. And New Zealand, Ms. Penelope Ridings, International Legal Advisor, Ministry of Foreign Affairs and Trade. New Zealand was the state whose declaration of intervention has been admitted by the court. Agents, counsels, expert advisors, and advocates for both parties were numerous. The original case. On May 31st, 2010, Australia filed in the registry of the court an application instituting proceedings against Japan. Quote, Japan's continued pursuit of a large-scale program of whaling under the second phase of its Japanese whale research program under special permit in the Antarctic, JARPA II, and breach of obligations assumed by Japan under the International Convention for the Regulations of Whaling, as well as its other international obligations for the preservation of marine animals and the marine environment. Australia requested that Japan is in breach of its international obligations in implementing the JARPA II program in the Southern Ocean. They request the cease of implementation of JARPA II, revoke any authorizations, permits, or licenses allowing the activities which are the subject of this application to be undertaken, provide assurances and guarantees that it will not take any further action under the JARPA II or any similar program until such program has been brought into conformity with its obligations under international law. Japan violated its international obligations to observe the zero-catch limit in relation to the killing of whales for commercial purposes, refrain from undertaking commercial whaling of fin whales in the Southern Ocean Sanctuary, observe the moratorium on takings, killings, or treating of whales, except minke whales by factory ships or whale catchers attached to a factory ship. JARPA II is not a program for purposes of scientific research within the meaning of Article 8 of the International Convention for Regulation of Whaling, and Japan shall refrain from authorizing or implementing any special permit whaling which is not for the purpose of scientific research within the Article 8. Cease with immediate effect the implementation of JARPA 2. Revoke any authorization, permit, or license that allows the implementation of JARPA 2. Japan maintains that its activities are lawful because the special permits are issued for the purpose, quote, of scientific research, unquote. As provided by Article 8 of the ICRW, it maintains that the present dispute, quote, relates to the exploitation, unquote, of a maritime zone claimed by Australia or an area adjacent to such zone. The maritime zones that they're talking about are invisible lines, also known as boundaries, in the bodies of water that give permission to different countries and the fishermen's to let them know where they can and cannot fish or whale. They also argued that this would be the case under Australia's characterization of JARPA 2 as a programme for the commercial exploitation of whales as scientific research, and that research conducted is an element of the process leading to exploitation. Quote, an overview of the alleged violations interpretations of the International Convention for the Regulation of Whaling and the question whether special permits granted by JARPA 2 are for purposes of scientific research. ICRW was preceded by two multilateral treaties relating to whaling. The first one is the Convention for the Regulation of Whaling that was adopted in 1931, promoted by concerns over the sustainability of factory ships and technological innovations to conduct extensive whaling. It prohibited killings of certain category of whales and required a license. 1937, the International Agreement for the Regulation of Whaling prohibited the taking of certain categories of whales, designated seasons, closed certain geographic areas, and imposed further regulations. The decision, the court unanimously found that the special permits granted by Japan in connection with JARPA 2 do not fall within the provisions of Article 8, Paragraph 1 of the International Convention for the Regulation of Whaling. The court found that by granting special permits to Japan to kill, take, and treat fin, humpback, and Antarctic minke whales in pursuance of JARPA 2 has not complied with the schedule to the International Convention for the Regulation of Whaling. They decided that Japan shall revoke any extant authorization, permit, or license granted in relation to JARPA 2, and refrain from granting any further permits in pursuance of the programme. The analysis. I think the decision was fair to revoke the permits. The evidence showed that Japan clearly was in violation of the treaties and the research program. Had their permits not been revoked, then the risk of the whaling population would diminish. Japan was using their permits to kill whales for commercial use instead of scientific research. And these are my references.